All right, good afternoon and welcome to our complimentary webinar for Franczek PC. Thank you for joining. We'll be reviewing today key decisions for educators from the Supreme Court during the 24-25 term. So we're delighted to have you here with us and thank you for joining. Please use the Q&A function at the bottom of your screen to submit questions, and we will do our best to cover your questions as we go. Today on our panel, we are pleased to have Bill Pokorny
Hi, everybody.
and Brittany Begley.
Hi there.
And I am Jennifer Smith. We are all attorneys at Franczek PC. Before we jump into our Supreme Court discussion, I want to highlight the many resources you can find on our website. It's franczek.com. Specifically under the Thought Leadership tab, you'll find alerts regarding cases we have that we're going to discuss today, along with other updates educators and employers need to know. If you do not get our alerts and want to, please email. You can email one of us, or I think we have a marketing email that you'll find on the website as well. We do send those alerts out to your email if that's a helpful service for you. Let's see, we also want to emphasize today before we jump in that we recognize some of these cases touch on very sensitive issues. By talking about these cases, we are not saying that the cases are good or bad. Rather, our goal is just to provide some additional context and explanation for what the court decided and how it might affect the law going forward. So with that, we will go ahead and jump in. So we wanted to start out with a bigger picture overview to kind of help digest and understand the court's decisions this year for educators. So we thought we would talk about key highlights. So Bill or Brittany, are there key things as we're talking about the cases that that folks could use as just a trend or topic that they're going to see that goes from case to case?
Sure, I can jump in on that generally, and then Brittany, feel free if you have any additional comments to add. I think through this last term and sort of a continuing trend with the Supreme Court, but made particularly clear by the decisions we've received at the last term and really even in the last few weeks, a couple themes have become clear. Number one, there are a number of decisions that touch on issues of religion and religious freedom under the First Amendment. We've continued to see this court giving substantial and a great deal of deference to religious freedom, and both expanding the rights of individuals and also under both the free exercise clause and also sort of limiting the scope of the establishment clause that prevents government from becoming involved in religion. So we'll touch on a couple of cases that address both sides of the freedom of religion under the First Amendment in the course of our presentation today. Another area that we've seen, particularly over the last few weeks with some of the decisions that have been coming out, both decisions on the merits of cases, and then also Brittany will talk toward the end of the program about some of the emergency docket, or what some people call the shadow docket cases, where the Supreme Court has sort of intervened to block lower court orders that limited some of the actions that the administration has taken in terms of cutting off funding or cutting down the size of federal agencies. So a great deal of deference to the executive branch, and in some cases limiting the authority of the judiciary to step in and address some issues. And then separately, there are some other cases that are, I think we'd I'd call them more normal cases where we actually will talk about a couple of unanimous decisions that are really just interpretations of statutes, and we're not as controversial as some of the other cases. So those are the three buckets that I'd identify.
Great. Well, Brittany, maybe I'll turn to you to talk about that first case, which I think is more in that normal bucket of cases we were talking about. It's the AJT versus Osseo Area Schools case. So Brittany, could you give us, just ground us in basically what is this case about factually?
Absolutely. So as a bit of background information, AJT is the student at issue in this case, and she is a student with epilepsy, and her epilepsy was especially severe in the morning. And so the impact of that was that it was difficult for her to attend school until the afternoon. And so as a result, her parents requested that evening instruction time be built into the student's IEP in order to make up for the morning instruction time that she missed due to her epilepsy or the conditions surrounding her epilepsy. The school denied this request to modify the student's schedule, and as a result, the parents filed for due process. The administrative law judge during the due process hearing found in favor of the parents. Moving forward a little bit, the student's parents, so AJT's parents, then filed a lawsuit, and they alleged that the district, in its failing to modify the student's schedule, their actions constituted discrimination under both the ADA and the Rehabilitation Act. And just procedurally, a little bit of history before we get into the Supreme Court's holding here. The lower court ultimately found that AJT's claims could not go forward because the student had not demonstrated that the school district acted with, quote, bad faith or gross misjudgment. And that's a more demanding standard than other types of disability discrimination claims. And so essentially, the lower court found that this heightened standard applies uniquely in the context of educational services. And so ultimately, this case was then examined by the Supreme Court.
And then moving to that, what did the Supreme Court find?
So as you mentioned, it was a unanimous decision, and the Supreme Court found that there is no need for a heightened showing of bad faith or gross misjudgment. It's not required in this context. So in other words, children who are bringing claims for discrimination related to education under the ADA or the Rehabilitation Act, they're subject to the same standards as other disability discrimination claims.
And what would you, big picture, how would you describe the potential impacts of this case?
So initially, it's important to note that the main effect of this decision will be in the Eighth Circuit, because that's where this decision was ultimately decided, where it changes the standard applied in student cases under the ADA and the Rehabilitation Act. Looking outside the Eighth Circuit, it might not substantively change how these cases are decided. That being said, anytime the Supreme Court addresses an issue, it does tend to draw more attention to that area of the law. And so because of that, and I know Bill can speak more to this as well, we might see more lawsuits that are not just seeking accommodations, but actually monetary damages. The decision also increases the likelihood that students with disabilities will file and be successful and win lawsuits alleging discrimination related to their education. And it really opens an avenue for parents to pursue money damages for allegations that a district violated the student's IEP, where in the past, those remedies are really limited to correct the educational violation as extra services or reimbursement for private schools. So it affords families more options in terms of remedies. Bill, do you want to
And
speak more to that?
yeah, and I can just say in my practice, we've seen, just relatively recently, cases coming in where parents are suing for money damages based on alleged violations of the ADA and Section 504. And even in the employee context, uh, uh, employees making claims of retaliation because they complained about issues involving students with disabilities internally, and so filing damages claims for retaliation under those statutes. So again, I don't know that this Supreme Court case necessarily, as Brittany said, is going to change anything about the legal standard that applies outside of the Eighth Circuit, because other courts already were not applying that heightened standard. But the fact that this case is in the news is only likely to sort of increase that trend of people pursuing money damages in these cases.
Yeah, and amongst our Illinois parents bar, I have seen some strategy change where they are filing both due process complaints and discrimination complaints through our state agency and then in federal court. And then leveraging and part of settlement discussions where we would always typically focus pre-hearing, there wasn't a money component, or attorney's fees would rarely be necessary to settle something that was just an educational dispute. Now, we're seeing a lot of aggressiveness about money damages and attorney's fees off the jump for even the due process cases. I think that we'll have to wait and see how this develops. It could be a blip that then there's some pilot cases that aren't successful and it goes back down again, or it's possible that we're here to, a more litigious landscape is here in the area of students with disabilities. So, that's the part that in all these cases, we kind of have to see how it develops. So that's a good segue into, there's another case also about discrimination, this time employment discrimination, the Ames v. Ohio Department of Youth Services. Bill, do you want to give us an overview on that case?
Sure. So in Ames, the plaintiff was a heterosexual woman who worked for the Ohio Department of Youth Services. She alleged that she was not selected for a position she'd applied for, and then subsequently she was demoted. And she claimed that was because of her sexual orientation, because she was heterosexual. In deciding that case, the district court initially applied a precedent in the circuit there, I believe it was the Sixth Circuit, that said that the court needs to look at the background circumstances of the discrimination claim. And one of the background circumstances that the district court analyzed was the fact that the plaintiff in this case was not a member of a historically disadvantaged minority, but she was claiming discrimination because she was heterosexual, which is sort of the opposite of the quote unquote typical discrimination claim that we would more frequently see. And so the Supreme Court took up the question of whether that was an appropriate standard, or whether the district court erred in applying circuit precedent and essentially holding the plaintiff in this case to a higher standard of proof than would apply to a discrimination claim by somebody claiming they were, for example, denied a promotion because they were homosexual. And the Supreme Court, and this is one of those cases that I would put in the normal bucket. The Supreme Court unanimously decided that, look, Title VII prohibits discrimination based on race, color, religion, sex, and national origin, pregnancy. There's no heightened standard for discrimination claims by somebody who is a member of a majority group versus a minority group. Discrimination is prohibited regardless of which side of the coin the plaintiff has to be on. And so the Supreme Court, construing Title VII, said, again, unanimously, that, look, the same legal standard applies across the board, regardless of who's bringing the claim. And like AJT, this ruling might not have much substantive impact, particularly outside of the Sixth Circuit. It doesn't really necessarily change how courts here, for example, in the Seventh Circuit, which is Illinois, Wisconsin, and Indiana, are going to be analyzing these claims. But it may draw some further attention to the area. And, we've been seeing, particularly with the emphasis of the new administration, trying to, eliminate DEI programs, for example, and going after employers that they perceive as engaging in quote unquote reverse discrimination. This case, does potentially fall in line with that initiative, and it may give some of those claims some additional traction.
Okay. Great. Well, the next case I'll take a stab at summarizing. The next one we're going to talk about is United States versus Scrimetti, which on its face is not an education case. Instead, it's about medical care for youth. So this arose out of Tennessee and Kentucky laws passed restricting gender-affirming care for transgender minors. So my understanding is 20 states have passed similar legislation, and it limited medical care based on two factors. One, age. This was a case in laws only applying to minors, and then also the type of care, the gender affirming care. At least that's the way the Supreme Court framed the key factors that were important in their analysis of these laws. The question was whether these laws violated the Equal Protection Clause of the 14th Amendment. And so the question there was whether it was discriminatory, and especially based on gender identity, to pass these laws and prohibit gender affirming care for transgender youth. That was the fundamental question. So what the court said, determined, was that the Equal Protection Clause requires the government to generally not be allowed to make distinction between classes of people in laws, so long as or they generally are allowed as long as there's a rational basis, unless it's particular classifications that have a history in our country of discrimination. So one of the key questions was whether gender identity is one of those classifications where, if you're making distinctions between groups of people based on gender identity, whether there's a heightened scrutiny to those decisions that governments make. And essentially the court determined that there is not heightened scrutiny under the Equal Protection Clause based on gender identity for minors. So then the bar for whether these laws were unconstitutional was lower than the plaintiff argued. Because then they only have to say a rational basis for making the distinction and imposing those rules for age and gender identity medical care. And the court reviewed some evolving medical factors that have gone on in the research in this area and what other countries do in this area. And they said there's enough for a state to make a rational decision to ban gender affirming care. So it's leaving those laws in place. We do not have one of those laws in Illinois, so it doesn't directly impact our state in that sense. But this is only part of the landscape of gender affirming care. And where we kind of shift over to the impact of schools is we have seen the new administration also take several actions in this area. So they've threatened funding of medical providers who continue to provide gender affirming care. And then also on the school side, you know, put out executive orders regarding how schools handle gender and gender affirming supports in schools. So one kind of an open issue, and one that our courts are immediately in this area going to look at, is how does this impact in our area of the country, the Seventh Circuit? We have clear precedent that schools must allow facility access, locker room, bathroom access, consistent with a gender identity, and that it's discriminatory and would violate the law not to do that. The Seventh Circuit, based on this Scrimetti decision, has in another case where a school district passed a law or adopted a policy that you could only access bathrooms and locker rooms based on birth sex. In that case, the Seventh Circuit said, we're going to reconsider our standard based on Scrimetti. So we don't know for sure the outcome of that, but they're taking it up, the question in the Seventh Circuit of whether the school could have a policy that requires birth sex access and not gender-based access. You can immediately see, you know, the impact of this precedent could have here in Illinois. So we don't know. The briefing on that case goes through September, early September. Usually it takes the court a while to issue a decision. So likely, you know, fall, winter, we're going to be getting more information about how this might be, this precedent might look in the educational setting. Brittany and Bill, any other takeaways you think on this case?
Yeah, so, you know, just one nuance of the case that I want to make sure comes across here, because it's the way this is all presented is in the decision is kind of confusing and difficult to follow in some places. But one of the issues, so the court didn't determine that discrimination based on transgender status is affirmatively not subject to heightened scrutiny under the Equal Protection Clause. The court decided it didn't have to reach that issue because it said this policy or this law in Tennessee and Kentucky wasn't discriminating based on transgender status. And so this gets back to a case from the 1970s called Geduldig. I think I'm pronouncing that correctly. So that was a case involving a California insurance program that excluded coverage for certain disabilities resulting from pregnancy. And the lawsuit was about whether that was sex discrimination, which is ordinarily subject to heightened scrutiny under the Equal Protection Clause. And the Supreme Court in that case said, look, even though this draws a distinction and, you know, discriminates against pregnant people or people who have had pregnancies and have disabilities related to pregnancies, all of whom are presumably female, it's not sex discrimination because pregnancy discrimination is not sort of coextensive with the idea of sex. And, you know, so that decision is part of what, for example, prompted Congress to pass the Pregnancy Discrimination Act, which says under Title VII that pregnancy discrimination is in fact sex discrimination for purposes of Title VII. But that's separate from the equal protection. So anyway, in this case, what the court said is, look, these states were not discriminating against transgender youth because they are transgender. They're the distinction that was being drawn was based on age, which is not subject to heightened scrutiny. And then there was a distinction between of people who, you know, of minors, between people who are using the gender affirming care that was banned by these laws and people who are not, which again was not coextensive with transgender status or sex, according to the court. And again, I'm not advocating for this position one way or the other.
Yeah, it just is what the court said. Yeah.
Right. This is what the court says. So the court said it, regardless of whether we think it was subject to heightened scrutiny or not, it wasn't discrimination based on transgender status or sex, and so heightened scrutiny did not apply. And there's also a footnote in the opinion that talks about, because one of the points the dissent makes is, well, you could apply that same logic to all sorts of discriminatory rules, and that could be problematic. In a footnote in the majority of opinion, the court says, look, this is dealing specifically with the medical context, and that's sort of different than the sort of general discriminatory laws that the dissent is worried about, so that's not really a concern. Whether it's this logic is actually going to be limited to the medical context, I'm rather skeptical. I do think it's going to be applied in other contexts. We just don't know how broad that will be. And again, that's part of what the Seventh Circuit will be looking at in these cases that they're now reevaluating.
Right. So I'm going to give it a go and see what you think. So because it's rather confusing, because they also talk about not every time you mention gender is it gender discrimination or so
Right.
so I imagine like the case where the school had a policy that said birth sex is how you access facilities. I think the parallel argument there is going to be you're not discriminating based on male or female. Everyone can only access based on birth sex, so it's not sex-based discrimination. I think that's how that kind of translates. Is that how you guys read it? Or
Right.
how the analogy would go, I guess, if
Yeah, perhaps. Again, I don't know how it's going to be applied, and it may come down to what is the specific issue. And I'm wondering if the Seventh Circuit might, for example, distinguish between sort of general bathroom access and locker room access for sports activity.
yeah,
We don't know.
we don't know.
I mean,
We don't know. Right.
the way the Supreme Court set this up is, it's very complicated, and it leaves a lot of questions open for the lower courts, which, is great for lawyers, unfortunately not great for everybody else,
Yeah.
because, there's going to be a lot of uncertainty in the short term.
Well, or also you raise the issue, there's other precedent. For example, you can't terminate someone based on transgender status.
Right.
And that remains untouched by this decision. So kind of where the line is drawn between can't terminate, but yet don't need to provide gender affirming care, and how those two concepts are harmonized. There's a lot of legal questions to
Right.
be answered between those two
Yeah.
concepts. Yeah.
Yeah,
Okay.
and specifically that, so in it was the Bostock case, Bostock versus
Right.
Clayton County, the Supreme Court interpreted specifically Title VII, which prohibits sex discrimination, and said that also, by definition, if you're discriminating based on sexual orientation or transgender status, that is by definition also sex discrimination. It's kind of, difficult to see how that decision squares with the logic that we saw in Scrimeti, and I think the Supreme Court is going to have to sort that out. It's also unclear, again, Bostock was a case about how to interpret Title VII. It wasn't about the Equal Protection Clause, but other courts have, and come to different conclusions about whether Bostock applies to Title IX, which uses similar wording to Title VII, or doesn't. And the Supreme Court is going to have to address those issues, particularly in education context. So stay tuned, folks. There's going to be a lot of additional decisions coming out that we're going to have to keep track of.
Well, and very concretely, we've seen already that the Supreme Court is taking up in their next term cases to look at laws about access to athletics and gender identity. So it's not speculative to say the Supreme Court will be revisiting this. We know that they've taken cases for the next term. And that's actually a good place to go to our next case, the Mahmood v. Taylor case. And Bill, do you want to give us a lay of the land for that case?
Sure. So Mahmood involves a school district in Maryland that, as part of its effort to make its curriculum more inclusive, particularly for LGBTQ plus people in the community, incorporated books in its language arts curriculum that, while they don't, the lesson is about language arts. It's, reading classes basically and these are for elementary grades, pre-K through 5. And so the books are trying to, the district's idea was we're going to try to include books that reflect diverse people within the community, including LGBTQ plus books. Now, initially, when this new curriculum was rolled out, the district did notify parents of the materials that were going to be used. And much like the district did for its sex education curriculum, it provided parents who didn't want their students to participate in lessons involving those specific curriculum materials to opt out of those lessons. As time went on, the district decided that that opt-out practice wasn't workable from a practical perspective. And the school board also had concerns about basically the optics of kids. The goal was to promote inclusivity, and there were concerns about the optics of when a book involving gay characters or a transgender student was part of the curriculum of their friends walking out of the classroom, and what kind of message does that send about inclusivity. So the school board removed the opt-out option for both, again, those practical reasons and the desire not to stigmatize students who identified with the characters in those books. The parents filed a challenge to the change in that opt-out practice and argued that not providing notice of the use of these materials, when these materials were going to be used, and an opportunity to opt their students out of these lessons violated their right under the Establishment Clause of the First Amendment to provide religious instruction and education to their children. And so in addressing this issue, the Supreme Court voted 6-3 along the typical party lines that the challenging parents were correct, that the school board's practice substantially burdened the parents' right to instill their religious values in their children by exposing their children to these materials, and what the court characterized as the normative lesson that the things depicted in these books were correct, and that contrary views were incorrect. At least that's how the majority interpreted the books and the lessons that were being provided. So the court found that the parents were entitled to a preliminary injunction to require the school to provide notice and an opportunity to opt out while the case proceeds in the district court. And so this is a little bit unique because this wasn't a final decision in the case. So the case goes back to the district court, but given the Supreme Court's decision, the district court is going to have pretty limited discretion to reach a different result.
Yeah, and could you talk, how did the court get there? We understand, I know there's the nuance, it was a preliminary injunction decision and they're only talking about likeliness, but what was their reasoning in finding the way they did?
Yeah, I mean, without, we could go pretty far into the weeds on the arguments that the majority made and the response from the dissent, but in essence, the court went back to a case called Wisconsin versus Yoder. You might have read this. I think I read Yoder in history class in high school, if I recall. But that was a free exercise clause involving Amish parents and students Wisconsin had a law that required compulsory attendance in public school through the end of 8th grade, or compulsory school attendance through age 16, rather. And the parents in the Amish community, had a practice of withdrawing their students from schools at the end of 8th grade. And that was, deemed a core part of their religious identity. So the court in that case reasoned that the compulsory attendance law placed an impermissible burden on the parents' ability to educate their children according to their own religious beliefs. In Mahmoud, obviously, it's a little bit different case because, as even the majority acknowledges, parents could always pull their kids out of school and either homeschool them or send them to a private school. But the court sort of went beyond the reasoning of Yoder and said that, look, public education is a public benefit. You can't condition receipt of that public benefit on parents giving up their right to educate their students in their own religious views and to their desire not to have them exposed to contrary reviews, at least at the K-12.
Yeah, and so in terms of how significant do we think, there are some key there's a lot, this whole case is very fact dependent, it arises on this opt-out issue. But what about the grade level? How much weight did the court, in your opinion, use that this was K-5? What do you think about that, Brittany?
So the court in its decision, it did note that the ages of the students were significant. And as Bill said, this was, a K-5 setting. And so the analysis might differ in a case involving high schoolers, right? Where there's a different ability to think critically, a little bit more sense of maturity there. However, again, it's not clear where the line would actually be drawn based on the court's analysis here. So, to answer your question, it really depends here.
Yeah, yeah. And so what do we think some practical impacts are going to be for schools? I mean, I can start out Yoder, the case Bill talked about, it just meant the kids weren't going to school. So in that case, there was, nothing the school had to do. So this is a much different case, although I just want to emphasize the opt-out was just the circumstances that kind of the factual background here. We don't know that there's not like a new law that it's like one way maybe of addressing parents' concerns in this area is an opt-out, factually, because that's what arose here. There's a lot of questions. I don't know, Brittany and Bill, what do you think kind of the open questions or the places where maybe it's prudent, even if we don't completely know how the case law developed, what might be a prudent steps to take given this case?
Bill, I can start and then add your thoughts.
Sure. Go for it.
You might see schools staying away from curriculum materials that touch on topics that their communities, or at least, parts of their communities might view as controversial. So you might see some avoidance on the part of schools. That's not entirely new. But Mahmoud would certainly intensify those considerations on the part of schools, to include in their curriculum topics that might generate a strong response from the community here. And, just procedurally speaking, it might be important for schools to review their procedures relating to parental objections when it comes to curriculum. Is there anything else, Bill, that you think on that point?
Yeah, I mean, so to the last point, first off, just a plug. We do have a curriculum objections toolkit that we're updating in light of the Mahmoud case. So if your district is interested in those materials, please feel free to reach out to us. I do think this is one of those cases that, in some ways was kind of driven by the facts that evolved in this specific case. I do think it was material that the school district initially provided notice of these materials and an opportunity for parents to opt out and then withdrew that. And that demonstrated to the Supreme Court that it is possible to have an opt-out procedure. And so the court says, well, you can just do that. On the other hand, the way the majority talks about some of the objections that the school or the reasons that the school gave for withdrawing that opt-out option kind of undercut a lot of the reasons that a school might have, that a district might have for not wanting to provide that opt-out in the first place. So, it's really hard to say exactly what level of burden on the school district might shift the scales. I do think reading the decision, it is talking about curricular materials and lessons that the students were required to participate in as part of the classroom. It's not clear, for example, that it would extend to books in the library or books that are just present that a teacher has available in the classroom for students to pick up. We don't know what the Supreme Court would say about that, but I do think that's potentially a different bucket. And we also don't know how this decision might apply to, the Supreme Court didn't seem to think that the things that the school district was trying to accomplish here were sort of core to the curriculum of teaching reading, was where these books were being used. It's unclear how this precedent would apply, for example, to a parent who doesn't want their children exposed to concepts of evolutionary biology. That maybe is a more explicit part of the curriculum that the school has, or to lessons as part of a history class that the parents disagree with for one reason or another. So once again, this is a expansion of parents' rights in this area, far beyond what we saw in cases like Yoder. And does require something of school districts, but the exact scope of what that is and how far that might extend, we don't know the answer to that right now. And that is unfortunately going to be hashed out in the courts as these issues continue to be litigated. So again, it'll be a fun time for lawyers, maybe not so much for people trying to navigate these waters.
All right. Well, staying somewhat on that theme of seeing religion come up in these cases, the next case we have, I'll just touch on briefly. It's the Oklahoma statewide charter schools v. Drummond case. And this case concerned whether a virtual a charter school that was a virtual Catholic charter school could get state funding, or whether which they were denied, and whether that violated the Establishment Clause of the U.S. Constitution. So the question before the court was whether that religious charter school, a religious charter school, whether having one would violate the Establishment Clause. And here, this is just sort of interesting. One of the newer justices, Justice Barrett, recused herself due to some connections she had. So we had only a 4-4 decision. And the decision is binding in Oklahoma and does not have a nationwide effect, but the case is still instructive ultimately on in that case, they said religion cannot be discriminated against in funding. And so it's kind of both the opposite side of the coin, freedom to, in the last case, we talked about freedom to religious expression. And this one, we're talking about religious practice being free from discrimination of the government, this time in funding. We don't know how far that will go. I'm not, and we don't know what application that would be, but it could be that this opens the door to funding of, religious private schools to a greater degree than it had been before. Anything you guys want to comment on that case? It's a little more limited in its application to.
Yeah, I mean, I think the ultimate result at the Supreme Court on this case, because of Justice Barrett's recusal, um, is obviously it limits the application to this case just to the state of Oklahoma. Had Justice Barrett weighed in, who knows what she would have done, but I could take a guess as to how the case would have come out. It probably would have been a 5-4. Well, I mean, it would have been a 5-4 one way or the other. And I'm guessing it might have had a different outcome if she had not recused herself. But, we don't know and won't know until the issue comes back. So,
Yeah.
Stay tuned for a repeat.
Yeah, we definitely, the door has been cracked, and invitations made that this is possibly an area where, you know, there could be merit in continuing to litigate that issue, certainly. Brittany, then turning to another, this is more the Department of Ed versus California. And then McMahon versus New York. What do you see in these cases? This is on the all the funding of the Department of Ed and the staffing of the Department of Ed. What are we seeing?
Yeah, so this really goes back to what Bill was talking about in the beginning with those three buckets. These two cases, the first is Department of Education versus California, and the second is McMahon versus New York. They both demonstrate this general trend we're seeing in the Supreme Court right now, where the court is vacating lower court injunctions, and giving deference to the administration. And both of these cases are emergency or what we call shadow docket rulings.
Okay, and I mean, I think all three of us in our practices, we're seeing the impacts of the change in funding and the layoffs that have gone through the Department of Education. I know, it seems the entire Illinois Office for Civil Rights attorneys were all laid off. I don't know that these cases impacted like they would have been brought back. I'm not sure about that, but regardless, I know if you email them, you will get a bounce back saying they are no longer employed. And I know some of my cases have been reassigned to an attorney out of Denver, but they are still working. I mean, the OCR is still in existence and is still processing cases, just at a much, much reduced staff. I don't know if you guys have seen similar or other things, impacts of the staffing change.
Yeah, I mean, that sort of applies across federal agencies. I think, staffing issues, both for whether it's reasons of budget cutbacks or, changes in enforcement priorities among different agencies. But there's, been a sea change, frankly, since the new administration took office. And in some cases that works out for educational institutions, in some cases that is a real source of frustration. So
Right.
across the board.
Well, those are really the cases we wanted to make sure our clients, know about as we go into the upcoming school year. I know we raised more questions than answers necessarily, so please obviously reach out for specific guidance regarding your circumstances. Any final thoughts, Bill and Brittany?
Just one other case I wanted to touch on briefly that wasn't on our list, but it fits that sort of same theme of deference to the administration, is the Trump versus CASA. That's the birthright citizenship case that came up relating to nationwide injunctions. So again, the Supreme Court did not weigh in on the issue of whether the Trump administration by executive order can revoke birthright citizenship. Under the 14th Amendment. What it said, though, is that lower courts, district courts, can't enter nationwide injunctions to block administration initiatives. Now, there are other procedural vehicles like filing a class action on behalf of all affected people, which is what happened in that case after the Supreme Court issued its decision. But, again, it's another example of the Supreme Court sort of stepping in to limit lower courts' ability to weigh in on the actions of the administration, particularly before getting to a final judgment or dealing with class certification, which is a whole additional procedural step. So, and again, it's one of those for better or worse situations, depending on which side of any given case or issue your organization happens to be on. We saw nationwide injunctions, for example, blocking the new overtime rules that were issued back in 2016, and then again more recently, those cases would be up in the
yeah, or a lot of educators on the call will probably remember the Title IX nationwide
right.
injunctions that were or it was piecemeal injunctions. Actually, it wasn't always nationwide. Sometimes it was school by school, depending if you have a student in a certain organization. That very complicated nationwide injunction. So yeah, when you say for better for worse, these will have kind of two sides of the coin depending on who's doing the federal action or the executive action, and it'll be interesting to see how this really plays out.
Yeah, absolutely.
All right. Well, thank you all for joining us. We appreciate it. Reach out to your forensic attorney if you do have any follow-up. Thank you.
Thanks, everyone.